This is a lecture about legislative history. This is about courts using legislative history in statutory interpretation. And in this lecture, we're going to do kind of an introductory overview or review if you are if you've already studied this. And so first, we're going to talk about what do we mean by legislative history. And the one thing to make sure you're clear on is that there's a lot of different items or types of documents that are produced by the legislature, and this could be Congress or a state legislature, while they're passing a bill. And some of you grew up watching Schoolhouse Rock and the I'm Just a Bill Sitting on Capitol Hill thing. If you search online, you can find the really nice flow charts that show the legislative process, so you can figure out when these different types of items and documents are produced. I'm less concerned about that than that my students are aware that these different things exist and that courts give different weight to them. And so first we talk about committee reports. So the legislature organizes itself into sort of specialized committees that deal with certain topics like budget or national security or the energy or environment or things like that. And so any type of proposed legislation, if it relates to that area of law, it gets referred to that committee before it goes to the floor for debate and a vote. And it's at that committee that they really hash out the verbiage of the bill or the proposed legislation, and talk about its policy goals and the exceptions that they need to have, or qualifications, things that extensions and so forth. And they go through different drafts or revisions or markups. And the committee reports are often mentioned by the US Supreme Court and other courts as the type of legislative history that's kind of the gold standard for legislative history, or what's given the most weight. And there's a few reasons for this. Number one, these are the people who actually haggled over, the people in the legislature who actually picked the wording or verbiage in the bill that eventually became the statute. And remember, the courts, the whole reason they're looking at this is to figure out what the words mean. And so they often are going to find their best discussion about that in the committee reports, where they talk about why they chose certain wording over others, why they decided to revise it to say something different than it did, or to drop an exception out or add a new clause or something like that. So in terms of the type of information courts wish they had from the legislature, they're most likely to find that probably in the committee reports. Secondly, these are the people in the legislature who know the most about this. And so because they serve on these committees for years at a time and are familiar with the existing laws and the policy issues and the parties, the different partisan positions on the issue and so forth. And so the stuff they say is not only coming from a more credible source, but it's also people who are just more informed about the subject than somebody who's on a different committee, has no idea, doesn't know anything, let's say, about environmental law or oil and gas law or something like that, who during the floor debates decides to grandstand and pontificate about it, and they're just kind of winging it. Now, and then the third reason that the courts give a lot of weight to committee reports in particular is that there's some evidence, anecdotal evidence from members of Congress, that they rely heavily on the committee reports from other committees when they're considering looking at legislation that they're not familiar with. And so they might kind of skim the bill, but if they care about what it means, they're more likely to read or skim the committee report to get guidance about that. Okay, the committees also sometimes hold hearings, and these could be public hearings or private hearings. They may invite people from federal agencies to testify, or people from nonprofits. or experts from academia to testify about things, and there will be transcripts. And so those become part of the legislative history. But remember, the hearings are going to be full of stuff that's just coming from outside, people who are not members of Congress, who have been, who wanted to show up and have an opportunity to be heard. And so it's not as clear whether a special interest group, let's say someone from the National Rifle Association or the ACLU or the Sierra Club, whether courts should give what they think much weight just because they showed up at Congress to testify at a hearing. The committees may actually have some sort of log or transcripts of their own debates on the markups of bills, which are is a little different from a report. A report is a formal write-up that summarizes the committee's findings and investigation and analysis and things like that, whereas the debate might be a little bit more of a freewheeling banter about which wording should go in there. So on the one hand, the words are less carefully chosen, so maybe we shouldn't read too much into them. And on the other hand, they're spontaneous, more likely to be spontaneous utterances of the people on the committee, and off-the-cuff remarks sometimes reveal more about what people really think than when they are preparing a formal report and can kind of choose their words strategically. I have conference committee reports. I have this underlined. Remember that after each house passes a bill, a lot of times they have the Senate version and the House version are a little bit different. And so a few members of each house are put on a conference committee and to reconcile the two versions of the bill. Sometimes these conference committees, there's not a lot, so they're not as extensive in terms of their reports or why they're doing things. So we don't always know why they chose certain wording over others, or if it was they were just trying to get something together. And then it goes back to each house for a sort of a quick thumbs up vote, let's say, yay or nay vote on the reconciled version, and it's almost always approved, right? There's usually very little debate at that point because the bill has passed, and the big vote is when it passes, and then it's sort of a perfunctory vote on the reconciled version that comes from the conference committee. So on the one hand, the conference committee reports are not necessarily from experts on this area of law, and there's less useful material sometimes there for the courts. On the other hand, it's kind of the last word from Congress about the statute before it's going to go to the president. And so if issues have come up or people have been expressing concerns about what courts are going to do with this law now that it's been enacted, sometimes that's going to be reflected in the conference reports, and whereas comments made early on might not be as reflective of like the mood of Congress as the bill worked its way through a committee. Okay, here's some other types of legislative history. We have statements and submissions by interested persons, both local or state government and private parties. And so this is very similar to what I talked about, people showing up at hearings, and people also can file something that's the equivalent of an amicus brief in the court with a congressional committee, basically saying we think the law should be this, or we think it should be this, or we don't think you should pass this law, and so forth. And again, these are part of the legislative history. They're not from Congress. They're definitely from special interest groups or interested parties. It could be from subdivisions of the government, but it can also be revealing about what was before the committee and what they were responding to. Then it goes to the floor, and we have these floor debates. And again, the floor debates are kind of spontaneous, and sometimes they can tell us what people were really thinking. somebody can throw out an accusation like this is going to favor some special interest group or something, and the bill's sponsor may have an opportunity to respond to that. So sometimes there's really useful stuff for the courts. On the other hand, the courts give less weight to floor debates because there are people in Congress who are notorious for just grandstanding or trying to filibuster, or they got to tie everything back to their pet issue somehow, no matter what the proposed bill is about, and so forth. And by the way, if you are ever reading legislative history and going through the floor debates yourself, they're very frustrating because they jump all over the place, and sometimes they are arguing about multiple bills at the same time, or they're supposed to be arguing about a bill and you're reading this debate and it feels like a trial transcript, and then all of a sudden they're arguing about another bill because somebody has kind of gone off script and is still mad about something from the session the day before, and then maybe the moderator of the floor debate will say, no, let's get back on topic, and so forth. So they are frustrating to read, and sometimes the comments are pretty low quality and are full of incomplete statements and people getting interrupted mid-sentence and things like that. A planned colloquy is everything that the floor debate is not, for better or worse. So a lot of times they will schedule something that's kind of like on the floor debate, except it's maybe the bill's sponsor and a representative from the opposing party, and they're going to have sort of a pre-scripted back and forth. When I teach a live class, I call this the between two ferns conversation about the proposed statute, where you have it's basically two people. And the advantage of this for a court in trying to interpret a statute is that usually the two people, and it's a planned colloquy, know what they're talking about. They are well informed, and they had a chance to kind of prepare their comments, their questions, and their answers ahead of time, and really put some thought into what they wanted to say. And so the answers are, and the comments in the planned colloquy are thoughtful and thorough and articulate or eloquent and things like that. On the other hand, they can be kind of contrived, right? Because you have an opportunity to kind of be calculating in how you phrase things. The same as a similar thing is prepared statements on the submission of the bill, and often these come from either the bill sponsor or its primary opponent. And so when you're proposing a bill in Congress or the state legislature, a lot of times you've prepared basically a speech for introducing it. And this could happen when it's first introduced before it gets referred to committee, or it could be after it's come out of committee and it's up for a vote. And very often the sponsor will get to talk first and explain what they think this is all about and why it's so important and necessary. The sponsor, again, from the court's perspective, the sponsor is the person who's really invested in this, really thought about it, cares about it, knows what they're trying to do. So in terms of like legislative purpose, the sponsor knows like why they introduced this in the first place, and they're going to articulate that. On the other hand, you kind of couldn't get somebody more biased about wanting to get the thing passed than the bill's sponsor. Revised and amended statements. So these are other members of Congress, and Congress has a strange procedure where members of Congress can manipulate the legislative history and have it edited, the transcripts of what they said. They can actually have requests that it be edited or cleaned up later to say what they wish they had said. And in modern times, there's a convention that's imperfectly applied of putting a little bullet point or dot in the margin next to statements that were not what was said on the floor, but are what the congressman afterwards corrected it to say. Imagine that you could have a trial transcript where you could go back and edit it afterwards, and that may be what we're talking about here. Then we have in here, this could be under the general like hearings and from the committees, but not everybody who testifies at the committee is treated equally, right? So you could have a talk show host or a celebrity, even a professional athlete who shows up to testify before a congressional committee. And that's not going to be given as much weight as, say, this the Secretary of Interior, or the Secretary of Labor, or someone who's the head of a federal agency and really understands the ins and outs of the agency that's going to have to enforce or implement the proposed law. And so maybe they should be given special weight. Okay, let's keep going. In the legislature, there will be, they have lawyers who are staffers who write up memos, kind of like the memo that you may have written for your legal research and writing class about proposed litigation or liability or statutes or something, and except this is a memo about the legality, and it could be constitutionally, or it could be how it fits within the existing statutory framework and things like that, by lawyers who are congressional staffers. Similarly, there will be people at regulatory agencies, often lawyers who are staffers at OSHA or the EPA or the Department of Energy or something like that, who will write a memo for the committee about pending legislation. Amendments accepted and rejected. So when a bill comes to the floor, people can, on the floor during the debates, propose an amendment to the bill. And before they vote on the bill, they vote on whether to amend the proposed bill to include that recommended language or to delete a certain clause or provision or subsection and things like that. Sometimes these get a lot of attention from the courts. They don't acknowledge that they're giving them a lot of weight, but they pay attention to it, because sometimes the position of one of the parties in litigation that they're trying to talk about, we have an ambiguous statute and one side says it means one thing and the other side says it means another. And one of their positions was actually proposed as express or explicit language as an amendment on the floor and then voted down. And so to a court, I hope you can understand why it may look like, you know what you're saying the statute meant, Congress actually had a chance to vote on that and voted that that's not what they wanted. And so now it's not clear that that's how you should interpret it. It could be that people just feel like the statute's long enough. Sometimes people propose amendments with the perverse incentive of trying to get hoping the bill will fail if it has that language in it. So that has happened where congressmen have said, I propose a certain, adding a certain language to this statute, knowing that it will never pass if it does have that language in it, and so forth. Also, what about discussions on separate bills that are on the same topic? And so if you'll pick an issue like gun control, for example, we have at any given session of the legislature, we have a number of bills pending in Congress, everything from universal background checks to expanding or restricting the ATF's jurisdiction or authority, to creating maybe a national gun registry, or changing how the tax, let's say, on there's a 11% federal tax on ammunition, and so maybe there's also a bill to raise that tax. There may be also an assault weapons ban proposed that comes around and around and around. And maybe a proposal to repeal something like the PLCAA that gives statutory immunity to gun manufacturers. And so there's a lot of legal issues, a lot of legislation. There's a large legislative framework already about firearm regulation in this country, and there's a lot of proposals that come and go in Congress, and usually several are pending at once. So imagine that during the debates on one of those, some of the congressmen are going to say stuff that's actually really relevant for interpreting another statute that might actually get passed. And so this, by the way, is a critique sometimes people have of legislative history is, wait a second, they weren't even talking about this particular law when in that quoted material, but actually they were talking about this law. It's just during in the middle of a debate about another related law. A similar thing would be if you think about the debates about the Affordable Care Act and providing health care for people that in the middle of that, they might have started talking about veterans benefits and the VA hospital, Veterans Administration hospital situation, because it was relevant, but it might have been just a related pending bill. Okay, then the question about recorded votes. And most judges, I think, and most law professors are going to say that these are given no weight at all. And personally, I kind of disagree, because I think that when a bill passes unanimously or almost unanimously with strong bipartisan support, when courts talk about that in their opinion, and they'll say the statute passed unanimously or with no opposition or something by the legislature, and sort of hinting that they should give a robust or expansive interpretation to the statute, like kind of make it go full throttle because there's it had such strong support in the legislature. What we don't usually see is courts applying the sort of mirror image of that and saying, you know, this narrowly passed, only passed by one vote, so therefore we should construe the words narrowly. But it's possible that they are tacitly doing that without saying it. And then again, another consideration that you should keep in mind, this isn't really a type of legislative history, but we do pay attention to what is the status of the person speaking. And in a sense, that does become part of the legislative history, because speakers will sometimes be introduced as the bill sponsor or the chair of the relevant committee, or something like that. Okay, let's talk about legislative history that's really antecedents. And so this could be prior legislation, and it could be on a related topic. So for example, if we have something like the Controlled Substances Act, our federal drug narcotics framework, we might want to talk about the early version of that passed in, I think, 1971. And then when we're debating a subsequent amendment to that, like the changes to enhance the penalties for crack cocaine in the 1980s. And so sometimes earlier legislation becomes essentially kind of, if it's the legislation as a precursor, it could be relevant to our discussion of subsequent statutes and enactments. And by the same token, if we had a statute that was a law for a while, and I'll give an example, the assault weapons ban that was a law for a while in this country and then was allowed to expire. And so you could have a former legislation that was either allowed to expire because of its sunset provision, or was repealed or amended, or something like that. When we're debating about like reenacting it or re-implementing it, it could be that a court would later on want to look at the fact that this was a law at one point, and then it's not a law, and then it could be a law again. And the same is true for actions taken. So sometimes I see court opinions that talk about how this bill was proposed in Congress like 3 years in a row, and it failed. And then in the fourth time it came up, you know, a different party had won a majority, and so now the law passes. And so again, I'll give another example. I've been using the gun one a lot. There's been a bill proposed several years to give, in several different sessions of Congress, to give copyright protection to fashion designers, people who don't traditionally have that. Like, so you design a dress for a celebrity on a runway, and there's nothing to keep somebody from making a copycat of your $20,000 dress that you made for a movie star to wear at a red carpet event, and then the next week it's hanging in Forever 21 or one of those types of Ann Taylor or something. And so we propose this year after year, and one of these years maybe it passes. And so then the question is, wow, we don't have a lot of good debate from the year it passed, but we have a really extensive debate about the meaning of the words, let's say in one of the year before, when they didn't quite have the votes and narrowly failed. And so the question is, can the court use that as part of the legislative history? And so this could be, and the same is true with proposals and actions taken in hearings or proposed legislation in the past that didn't pass. Another thing that you'll hear talked about are common law antecedents. And in my classes, we do a few cases like this where we get a statute and the Supreme Court has a big old discussion about the cases, the case law, and either that there was a common law doctrine that essentially was codified and turned into statutory form. Let's say the felony murder rule or something like that, or some of our crimes of fraud. And for the forgery statute, there was a common law crime of forgery. And so when the courts discuss the forgery statute, a lot of times they talk about the common law cases before the statute was enacted that kind of had defined the term forgery or fraud. Or sometimes you'll see the court talking about how Congress passed a bill basically in response to the Supreme Court misinterpreting, interpreting a statute in a way that it didn't like and they didn't agree with. So they've amended the statute to clarify it. And so that can be really relevant. And then the last point in terms of antecedents is, as you probably know, there's a few legal reform entities like the American Law Institute, that's probably the best known, but there's others that kind of create off-the-shelf draft model legislation, like the Model Penal Code or things like that, the model rules of professional conduct that the ABA creates, the Model Code of Judicial Conduct. And so the legislature, whether it's a state legislature or Congress, might be actually just borrowing a uniform act, uniform code from the National Conference of Uniform State Laws, or a model law from the ALI, or sometimes they are just plagiarizing essentially the statute of a neighboring state and so forth. And so then the question is, it can become part of the antecedent, like where did this law come from? It didn't just originate in the minds of the legislature. This was hashed out at the ALI, and they wrote extensive reports and official commentary on it, and so forth. Okay, there's also a question about whether we can have legislative history that's really from the executive branch. And so sometimes, as you know, like one example would be the Affordable Care Act, where this was really President Obama's signature kind of act as president, or legislation, or his big achievement was getting we called it Obamacare. And so there was a lot of communication from the White House during the Affordable Care Act and so forth. So this could be executive branch messages, proposals from the president or cabinet secretaries, or even independent agencies like the Federal Trade Commission. And then we could also have prior relevant administrative action or interpretation. So let's say the Securities and Exchange Commission has always taken a particular position on something, a legal position on an issue, and could that be essential, and that's in the background of a congressional action. Very common with the IRS and Treasury regulations that are not statutes, but get discussed a lot by Congress when they're debating changes to the tax code, to the tax law. And then we have this phenomenon of presidential signing statements. Recent presidents have kind of really taken this to a new level, writing whole pages or paragraphs about how they think parts of the law are unconstitutional, and they think they're trying to do essentially a type of legislative veto a line item veto, and with a signing statement. I've never seen a court give these any weight, but they are out there, and presidents do write them. And so in theory, a party could bring it up and say, look, the president is part of the production process for enactments. They have to sign it. And so this is what the president thought it meant. And maybe that could be part of the legislative history. Okay. We also have post-enactment legislative history. I have a nice picture here of everybody's gone home from Congress. So should it be part of the legislative history, let's say that the statute was amended later on? or that we've had, and then, or the courts interpreted it a certain way and then we made some changes to it. This actually matters more than you think. That my second bullet point here. Sometimes we have seen courts say that, okay, Congress fiddled with this statute, made some amendments to it, let's say in 2005, and in doing so, they didn't change the parts of the statute that the Supreme Court had interpreted back in the 1990s. So therefore, the court subsequently in 2015 assumes that Congress was tacitly endorsing its interpretations of the parts that they left alone when they amended other sections of the statute. And so this can get very complicated, that when you get an enactment later on, this can be taken as an implied endorsement of the judicial interpretations or construction of the statute since its original passage. We also have situations, and courts vary, and sometimes they cite these. It's not clear how much they give weight to them. Congressmen write affidavits submit affidavits and amicus briefs to the Supreme Court sometimes, saying, I was there when we voted on this and I think it meant this and I want the court to interpret it this way. We have post-enactment comments of legislators placed on the record sometimes, or made to the media. So you get somebody who, even after we've called the vote, they get up and they start giving a speech about, like, this was the end of democracy, this was a travesty of justice, what we just did here, and I think the statute means this. And so the question is it part of the legislative history if somebody keeps talking after we've counted the votes? And does it matter if they put it on the record, or does it matter if they step outside the building and talk to reporters on the steps of the Capitol? We can have express or implied repeals. And so sometimes Congress expressly implies something. Sometimes they pass a new statute that makes a previous statute basically defunct by implication. And so we can have these kind of implied repeals that will be the subject for another lecture. And then this will remind you of the case TVA v. Hill. That's in a lot of statutory interpretation casebooks and administrative law casebooks, where Congress passed a law, passed a law, the Endangered Species Act, that was used to halt construction of a dam that Congress had previously allocated millions of dollars to construct by the Tennessee Valley Authority. And then even after the litigation was underway, Congress continued to allocate tens of millions of dollars year after year to and expressly saying we want the dam completed, but didn't really mention the problem with the Endangered Species Act that they had passed in the meantime. And the traditional rule, just for my students, is the courts disfavor reading a lot of significance or meaning into budgetary allocations or apportionments. But keep in mind that sometimes it happens. Sometimes courts take note of the fact that the legislature defunded something, like pulled the plug on something, and which it could be kind of a way of repealing something by statute, or they keep throwing money at something, kind of suggesting that they think it's still legal. Okay, when you're evaluating legislative history, always ask yourself, how deliberate was the statement? And should we give more weight to something where someone had a chance to really think about, choose their words, prepare the statement ahead of time, put some thought into it about how they wanted to express it and so forth? Or was it sort of a spontaneous, off-the-cuff remark on the floor? And there's, as I've mentioned, pros and cons to this. A deliberate, pre-planned statement is likely to be more thoughtful and maybe less prone to somebody having misspoken or saying something that choosing their words poorly. And on the other hand, it could be contrived and calculated and manipulated, and an attempt at manipulation, whereas a spontaneous statement and evidence, right? Spontaneous utterances are sometimes given extra weight for admissibility, or it can be an exception to hearsay in certain situations. the reliability, like was this altered later, or do we really know what was said? And then the representativeness. And so there's always a question, like the bill's sponsor knows a lot about the bill. If anybody knows what the bill was supposed to mean, it should be the bill's sponsor. On the other hand, it's one person and there's 537 other members of Congress. And related to that is how knowledgeable. So not just how is this person speaking for the group, but do they even know what they're talking about? And the representativeness of the source, I think I already covered that. And then think about the actual impetus for this law, and also partisanship, and whether the statement of somebody is coming, they're just from the opposing party of whoever sponsored it, and so they're going to criticize whatever they do no matter what. And so now we don't often see courts talking about that, but they often do mention that this was that so-and-so was a Democrat or so-and-so was a Republican, which may be implying that either they were biased because they wanted to support what their own party was doing, or sabotage what the other party was doing. Again, I mentioned this before. Remember, we have previous versions, and so you could have what happens when we have an earlier version of the bill that said exactly what one party wishes the law said now. And so is that a hint that maybe this is what they were thinking all along, or does it imply that they considered this and rejected it? And the same is true for floor amendments, right? So if somebody stands up and said, I propose an amendment to this to add an exception, let's say for senior citizens, something like that, or for members of the military. And does it matter that this was a last minute amendment when people had just wanted to get the bill passed? If the amendment fails, should we read a lot of significance into that? And because it shows that the idea was considered and then rejected. Just a quick note, history of legislative history. Remember the traditional rule that parliamentary history was off limits for courts to cite in the UK during the common law period. So it was not part of the common law tradition before the 20th century to cite legislative history. The first big case, of course, was the Church of the Holy Trinity case that we cover in a lot of my classes, which is from the late 1800s. And for our common law history before that, and especially in England, they didn't cite parliamentary debates. Keep in mind that before the 20th century, legislative history records were less available and less reliable and less complete, right? So courts things weren't available. You couldn't research it online. Everything had to be a hard copy. If you lived in a rural area, your law library was at the courthouse was going to be smaller and than in a big city, and so you might not have all the resources. A lot of times legislative history, you actually, if it's state legislative history, you have to go to the state capitol and the library at the state capitol to get it. And so a court in a remote location may not really have it, and the lawyers there may not have it, especially before the 20th century. And then also before the 20th century, there were simply fewer statutes. Remember, common law system, we're relying on judicial precedent, and statutes are the exception instead of the rule. And so courts had to interpret statutes less frequently, so they are looking to legislative history. They have less occasion to look at the legislative history. We're almost done here. After things started to change, after the Civil War, we had an ascendant federal government. It felt like they had won the Union, and so Congress starts legislating about more issues after the Civil War than they ever would have done before. There was a growing perception among educated elites, the people in power in this country, lawyers and judges and law professors, that statutes were more modern or maybe more European or like continental and therefore more sophisticated or more progressive or something like that. So as we come into the 20th century, people think statutes are smart and sophisticated and common law is primitive. And also remember there was a codification movement that really ramped up after the Civil War and coming into the early 20th century. Before that, statutes were arranged, the statute books were all arranged chronologically based on when the laws were passed, which made it really, really difficult to figure out if a statute had been amended over the years or whether there was a statute out there. And the codification movement was when we started to arrange statutes topically and enactments topically and have numbered titles and sections of the code and kind of give an address. So it was made it much, much easier to look things up. If you wanted to know what the statute was for let's say federal mining, mines or Indian affairs or taxes or something like that, you could find that section of the code and look at the pages, and there would be subsections, and probably if you turn the page, it's still on it's another law about the same subject and so forth. And that made it way easier for courts to find the actual statutory authority. And it made it easier for legislators to find it and then to notice that there were gaps that needed to be filled, to amend and expand prior enactments. So once you have a nice codified statute, section 123, it's pretty easy to add a section 1 to 4, or to add a C if you have an A and a B, and kind of keep bulking it up. Also, when we come into the 20th century, in the New Deal, the 1930s and 40s, this brought a huge expansion in legislative efforts to fix the economy, to address poverty, and to modernize the country's infrastructure. Another thing to keep in mind about the use of legislative history is that there was this very, very influential law review article published in 1950 by Carl Llewellyn, who was a luminary in the legal academy, that really blasted the alternative, which was the traditional canons of construction. And so he just ridiculed them. It was kind of devastating and had a huge impact on the next, like, maybe 2 generations of judges and lawmakers after that, to view the canons of traditional common law canons of statutory construction as a joke. And it made it more legitimate to use legislative history instead. And then also we start to have, as courts use legislative history more, Congress assumed they were. And so Congress had an incentive to bulk up the legislative history. So in other words, the more the courts used legislative history, the more legislative history would be generated the next session of Congress, because they knew that the courts were using it and it mattered. And so everybody had an incentive to throw stuff in, to add more reports or to go into more detail in the legislative history, because now it mattered and it could affect the outcome of future cases. Okay, that's the conclusion of our quick overview of legislative history. In a separate lecture, we'll talk about some of the objections to using legislative history, or the critiques of it by the modern textualist movement.